Hey guys, it's Jack. I wanted to let you know that we're starting a new push for subscriptions here on Human Events Daily. So make sure that when you're listening to this podcast, you hit subscribe, you download it, and you share it with 5 of your friends. Make sure they're all going and downloading as well, because we need to get the signal out as much as possible. Look, we've done so much over the past couple of years since this show started, and we're only going to do so much more. Let's get it. This is what happens when the fourth turning meets fifth generation warfare.
A commentator, international social media sensation, and former Navy intelligence veteran.
This is Human Events with your host, Jack Posobiec.
Christ is King.
Were you able to determine at what time or times Mr. Robinson visited the UVU campus on September 10th?
Yeah, we were able to establish that Mr. Robinson had been on campus approximately 4 times throughout the day, twice before the shooting, the time of the shooting, and then after the shooting later in the evening into the early hours of the 11th.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes. Yes.
Who is that?
I believe that's Tyler Robinson.
All right, where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
As the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views.
Edition Human Events Daily. We're here live in Provo, Utah. Our special coverage of the Charlie Kirk murder hearing. And today is July 7th, 2026, Anno Domini. Special shout out, of course, to our partners at Allegiance Gold, who are providing security for us and for the team throughout all of the endeavors while we're here. There's more people now showing up at the courthouse, outside the courthouse. It's starting to get packed. It's starting to get heavy. The tension outside is building, as is the tension inside. And what can I say? Sitting there just feet away from Charlie's parents, Erica sitting quietly, but you can see the emotion. I had my rosary out. Other people had rosaries out as well. Tyler Robinson's parents just about one row away. There are SWAT officers all over the courtroom, in the seating area, in the gallery, and then there's sheriffs up in the front area, and just on the other side of the bar, a couple seats, a couple chairs, and right in the middle, dead center, was the accused assassin himself, Tyler Robinson. And today in court, the evidencing that it's piling up, it's just piling up. There's the surveillance footage, the digital footprints, now the DNA, the forensics coming in, the 95% match of Tyler Robinson's DNA on the towel, then another 89% match on the screwdriver. Again, these are huge numbers that the FBI was putting up in terms of the analysis of those documents. I'm just going over some of my notes here, but this was a huge day. And the biggest piece I think that came out today was there was a Bible verse that the defense was very, very, very adamant did not be read in court today. Because, of course, it speaks to the motive of killing Charlie. And in fact, it was a defense lawyer who became very flustered when he was losing the argument. And he stated that the state is making it out that the motive was anti-Christian. The anti-Christian motive for murdering Charlie Kirk. I want to read that Bible verse to you. The defense tried so hard to block. It's Matthew chapter 19, verses 4 and 5. Have you not read that the one who made them at the beginning made them male and female, and said, for this reason, a man shall leave his mother and father and be joined to his wife, and the two shall become one flesh. Now we're asking about, is there an intersection of politics and religion? And I'll tell you right now, obviously, there is an intersection. And we are going to discuss that, whether or not the defense likes it, because it is part of this case from the start and all the way through to the bitter end. Jack Posobiec, Real America's Voice. I want to thank them for all their support here, Provo, Utah. We'll be right back. Special coverage.
Now it's time for everyone to understand what America First truly means. Welcome to the Second American Revolution.
All right, folks, Jack Posobiec, we're back live here, Provo, Utah. Special coverage, human events, daily, Real America's Voice. And we want to welcome you back in to the Human Events special primetime coverage of the Tyler Robinson hearings. And we are covering, of course, one of the most high-profile murder trials in the country. And when something like this happens, it is a reminder of just how much personal information is sitting out there for anyone to find. There are hundreds of data broker websites publishing your name, your address, your home address, your phone number, your family members, and even old addresses, email, everything, pretty much everything that's been leaked about you online. Unless you take action, it's going to stay out there. Someone who knows what they're doing can piece together where you live, where you have lived, who you're related to, and even public property records. If you're politically active, you work in the media, you attend public events, or you simply value your family's privacy, it's not something to take lightly. If you don't want strangers finding your information, tracking down your social media accounts, or combining your personal details with information from data breaches, you can do something about it. Patriot Protect helps remove your personal information from these data broker sites before the wrong people get their hands on it. This isn't something you do after you become a target. It's something you do beforehand. Other services tell you after something has already gone wrong. Patriot Protect helps make you much harder to find in the first place. A single phone scam or identity theft incident can cost thousands of dollars. It's a lot less expensive to protect yourself now. Go to patriot-protect.com or call 1-833-367-8787 and use promo code POSO to save 15% off. Take control of your privacy. Add some digital camouflage to your life and make yourself much harder to find online. All right, I want to bring in now Will Chamberlain from the Article 3 Project to go through some of this legal analysis. Of course, I can present my perspective from having been in the courtroom, seeing what I saw, but Will is able to come in here, as he always does, and has been doing from hearing to hearing to hearing on the actual on the actual legal side of all of this. Will, how are you?
I'm doing great, Jack. Good to be with you.
Will, how would you score the first 2 days of the hearing, day one, day two now?
This is just an overwhelming presentation of evidence by the prosecution. I think the Robinson defense, as far as I can tell, didn't score a single point that was relevant. There's just an overwhelming amount of evidence of different kinds that all matches the basic story that we've heard since 48 hours after the shooting, which is that Tyler Robinson did this. Managed to bring a 30-06 rifle to the roof of this building, take a shot, and then get away. And I mean, we have the combination of video evidence of him showing up on campus 4 different times, including a few times on the same day. We have the car that he drove in being registered to him. We have the physical evidence. Obviously, you talked about the DNA evidence of the towel that the gun was found wrapped in, the screwdriver found on the roof, and the sniper's perch. And we haven't even gotten to the text communications and the fact, the involvement of his parents in terms of identifying him yet, and the whole story of how he ultimately turned himself in. This is overwhelming evidence. It's surprising. It's surprising to me that the defense decided that it was a good idea to have a preliminary hearing. I think in their spot, the only burden here that needs to be met is probable cause, and it's been met in spades already. It's kind of interesting that this hearing is continuing on for days and days, because if I was in the judge's shoes, I'd feel no problem about going forward and saying there's probable cause here. Let's set a trial date. Well, and it it just goes to show you that, look, for example, in the second half of the day today, we have this DNA evidence that's introduced. The forensic tech shows us that, okay, there's two individuals that were found on these 2 items. This was the screwdriver and then the towel. And she's saying, look, there's a 95% match to Tyler Robinson on one, 5% to Twiggs. Then the other one was 89% Tyler Robinson. The second one was the minor contributor. That was 11%, again, to Lance Twiggs. And so we get that piece of information in, and then the defense spends, I'd have to go back and look, almost 3 hours of time just filibustering about whether or not DNA evidence itself, the science of DNA, can be used to match someone and the standards of the FBI lab at Quantico, and over and over and over. And I have to say, I think the FBI tech handled herself very well. And to me, she gave a masterclass in, I guess, what I would call positive demeanor, the power of positive demeanor, in that she was never combative, she was never argumentative, but she was firm and she was positive. She was always very polite. She would sort of say, no, I don't agree with that, actually. And she would walk through her reasons why, but never snapped, never lost her temper, and clearly someone who's highly skilled, highly capable, and very proud of the work that she did. So, again, to your point, I don't think the defense scored points there. I think they lost points clearly with the judge, who, I don't know if you could see on live stream as much, but in person, he seemed to be getting extremely frustrated with the defense. Oh, I'm sure he was. I mean, the idea that, you're going to waste my time into a preliminary hearing. It's not even the trial yet. You're not talking to the jury. You're literally trying to persuade me, the judge, that there's no probable cause. That's, theoretically what you're trying to accomplish here as the defense. And your way of doing that is to try and tell me that DNA evidence isn't real and that DNA's technology is fake. And that's your argument for probable cause. And you don't have an expert coming up to testify to that effect. No, it's just you, the defense lawyer, trying to tell me about how DNA is fake. I mean, think about 2 things, right? Think about, first off, how many criminal trials has this judge dealt with over his career? I mean, he's probably dealt with dozens, maybe hundreds. Many of them will have involved DNA evidence. So he's going to be personally quite familiar with the science of DNA evidence, actually, because he's probably heard a lot of experts testify about it. And he's probably going to have sent a lot of people to jail on the basis of DNA evidence. So for the defense lawyers to think it would be a really good strategy to just attack DNA evidence as a general matter, as a general idea, and attack the underlying science of DNA evidence, broadly speaking, the idea that would be a useful way for him to spend time is ridiculous. So I'm not surprised that the judge would have betrayed some impatience with this line of questioning. Certainly, and the extensive nature of it, bringing up textbooks, studies from 20 years ago, and I might add, and something that a few of us noted, that he brought up I guess a commission from the Obama Department of Justice that was pushing back, and I thought, my goodness, here's something for us to maybe dig in on a later episode to see exactly what the Eric Holder Department of Justice was trying to do in undercutting DNA evidence, because that's clearly what they were trying to do. And I really did appreciate how the FBI tech Amanda Baker just really dismissed it out of hand. Oh, those aren't experts. That was political. It's like it was just completely rejected that entire line of argument.
Yeah, I mean, I think that this is obviously going to go nowhere, and in particular, it's not going to go anywhere at a preliminary hearing in front of a judge. Maybe they can find a juror who's skeptical of this stuff, and maybe that's the point. Maybe this is all to further sort of online conspiracy theorizing, giving something to the baying mobs to say, you could ignore this DNA evidence and continue spewing your nonsense on podcasts. Maybe that's the point of these lines of questioning. If the audience is the audience is actually the few podcasters and diehards who really do, want to continue this narrative that Tyler Robinson didn't do it. I think that might be what the defense is trying to accomplish here, to sort of, continue to muddy the public waters in this respect. But certainly, I don't think the judge is impressed in the slightest.
No, and neither were really anyone in the courtroom that I spoke with, and It really seemed to be an exercise in what can we do to delay, what can we do to obfuscate, rather than actually focus on the very clear evidence that is now coming out, and one of which, and I would love, and I can't wait for it to come out online, but the fact that it remains to be seen that we now have 4K quality footage of Tyler Robinson, is obviously him, walking around on campus, walking around on the day of, changing his outfits, and the judge didn't play it in court, but zoomed in footage of him prone in the sniper position, crawling across the roof, taking the shot, and then running back across the roof to jump down. I mean, Will, I've even heard a lot of people saying that people who were on the fence, that footage, just the high quality footage of him walking around campus, really started to change their minds.
Yeah, I should hope so. I mean, this is just the beginning. I mean, we're still at the preliminary hearing. We haven't even gotten to the trial presentation of this stuff. My goodness, you got to think about how much else they're going to have. When they get to the real live testimonial evidence. It sounds like they're also going to be putting Twiggs, his boyfriend, on the stand. What's Twiggs going to say? I mean, nothing Twiggs said to
just
Robinson
real quick on that,
is privileged.
Just real quick on that, I believe they are going to be doing a taped testimony and playing a tape of that here at the preliminary hearing. To your point, obviously, yes, he will go on the stand at the trial, but that's something where, and we'll see whether or not that actually gets played this week, because certainly things are taking their time here in Provo, Utah. Special coverage, Human Events, Primetime, the Tyler Robinson hearings. Right back, Jack Posobiec, Real America's Voice.
Influencers. These are influencers, and they're friends of mine. Jack Posobiec. Where's Jack? Jack, he's done a great job.
All right, folks. Jack Posobiec back live here. Welcome back to Human Events special primetime coverage of the Tyler Robinson hearings. We're live in Provo, Utah. This is day 2. I want to say thank you again to our special sponsor this week, which is Allegiance Gold. And before we get into that, we really need to thank them for making all of this possible. Look, covering a trial like this from the scene and, in this point, even in the room, it takes a lot. From behind the scenes, including the security that's been required for our team to be here safely. Their support from Allegiance Gold is a big part of making it possible, and we're so grateful for it. Spending time here also reminds me that security means different things to different people.
For us this week, it's physical security, while we are, of course, right here on location. But for all of us, it's also about financial security, doing what we can to protect our families and what we've worked hard to build. That's why I'm especially thankful for Allegiance Goldman. We've been working together with them for the past 5 years now. And relationships like that are not built overnight. They're built on trust, consistency, and showing up for one another. We appreciate their support for this special coverage, and we're so proud to have them standing with us. If you would like to learn more, here's what you do. You go visit protectwithposo.com. That's protectwithposo.com, or give them a call, 844-577-POSO, and you will learn more. I want to get Will Chamberlain back on here. And Will, there's so much that's come out in terms of all of this, the video, the surveillance footage, the digital prints. One thing that I want to point out, there was something, it was just a little tidbit that Agent Hull had mentioned early on, the former FBI special agent. But one of the things that he mentioned was that, just a new nugget of information, but that Tyler Robinson ate Chick-fil-A prior to going and getting the rifle from the car and coming back to campus. Now, I'm sure that's something that people can, make a lot of hay about, but there's actually something significant there, and it's similar to this report that he was at a Dairy Queen afterwards. If he was making purchases there using a credit card or a debit card, that can be tied directly to him, which means that aside from just having this high-quality footage, we can also see things like having his credit card and debit card, finding that digital transaction. We can then use those finances to say, yes, this was his card, in the same way that having the police officer with that interaction late at night had the license plate, which was independent. And I guess, Will, what I'm saying is that there are going to now be more ways to even further corroborate this bombshell video that's coming out in court today.
That's right. I think I didn't actually think of that personally, but yes, you're right. If he was, any sort of financial transactions, which is as simple as buying food or buying gas, is going to, if he used his credit card or the credit card of somebody in his family, it's going to place it at the scene or on campus. And remember, he lives multiple hours away. There's no reason for him to be there. Why is he showing up 4 times in a day? What's he doing if not this? So you have, you just have, and that's going to be layered on top of, if he brought his phone, then there's going to be a whole phone signature about where his location was vis-a-vis the phone records. So you're going to have all these different layers of evidence that are going to place Robinson at the scene and put the gun in his hands. And, I think what the defense is going to try and do, it's like, okay, maybe you ask a question about one individual piece of evidence, like, okay, you try and say DNA evidence is fake and we don't know that it's real. Okay, but then you've got 4 or 5 other layers of evidence that place him on that roof. So are those all fake too? Is everything fake? None of that's going to work, and it's not going to work on a normal jury. It's certainly not going to persuade a judge. They're really just, at this point, the judge is just going to keep being annoyed if the defense is just going to, basically go on full on epistemology. Like, how do we actually know that DNA evidence works? How do we know that, who was behind the camera? How do you know this video evidence is real, et cetera, et cetera, et cetera? That's just not going to impress anybody.
No, again, and little things like saying, well, can you really see the markings on that shirt? Or I think Kathy Nestor at one point was asking the agent, did you tell if anyone had gone up on that roof after you had left the roof and they secured it, but before this video? Just nitpicking these little things that don't actually add up to anything, because we can see on the video that there's nobody else on the roof. It's right there on video. So no, he didn't need to go and physically look himself, because it's right there on video, so people can see all of this. And so, Will, to your point, any of the points that they think they're going to be making are actually all falling by the wayside, or ultimately just delaying the inevitable, because this evidence is all going to be presented. They're not going to get rid of the DNA evidence. They're not going to get rid of the ballistics evidence. They're not going to get rid of the autopsy. And so even though these things, okay, we can't publish it publicly, et cetera, yes, okay, that's perhaps a fleeting victory for you right now, but ultimately that's still evidence in court that's going to be building a case that is very much stacked against your client.
Yeah, I mean, this is one of those circumstances where it's going to be extremely difficult for them to tell a competing story. That's normally what good criminal defense lawyers look like for this. Like, you have all this evidence that's going to be admitted, and if it points to your client, you need some sort of alternate explanation for why it's true, or what happened that is innocent. And there is no. The problem is there is not going to be an innocent explanation for the overwhelming mountain of evidence that points to Ty Robinson being the shooter here. And so as a result, this is the kind of case where, if you're a defense lawyer in a normal world, you're trying to tell your client to plea out. I think it's kind of, you normally don't see cases like this with such an overwhelming amount of evidence go to trial. There's sort of an understanding that these cases need to be pled out by the defense lawyer. I think the unique thing here is because this was a public assassination of a major political figure in our friend.
Certainly.
Yeah.
Certainly we will see. Will Chamberlain, where can people go to follow you?
At Will Chamberlain on X, and you can follow what the Article 3 Project is doing at a3paction.com.
All right, check them out, folks. Human Events Primetime continues.
Where's Jack? Where is he? Jack, I want to see you. Great job, Jack. Thank you. What a job you do. We have an incredible thing. We're always talking about the fake news and the bad, but we have guys, and these are the guys who should be getting Pulitzers.
All right, Jack Posobiec, we're really excited to welcome you back to Human Events Primetime here on Real America's Voice. Want to give a shout out as well to the Real America's Voice team for all of their support in allowing us to do this out here in Provo, Utah. I want to bring on now our next guest, Andrea Burkhart of Andrea Burkhart Law. Andrea, how are you?
Hey, Jack.
Well, thanks so much for joining us. Now, I'm here in the courtroom, so I'm not able to watch your live streams, which is normally how I really enjoy to watch these. So I wanted to say thank you for putting them out there, but it also, of course, means I miss your analysis. So wanted to get you on here to hear how is it that you're sort of scoring these first 2 days of the hearing thus far. Do you think the prosecution is doing what they need to do, and what's your sense of how the defense is?
Yeah, absolutely. I think that at this point, there's very little question the prosecution is going to meet its burden to show probable cause to justify the charge. It's not a particularly high burden, especially in Utah with some of the just legal nuances that apply to the standard there. That said, I do think the defense has taken the opportunity to try to point out some open questions, some possible holes that may need to be closed or at least examined at some point in the investigation. So it's giving us a little bit of a clue about how they may be working towards generating a probable cause, a case for reasonable doubt.
Well, and that does seem to be what they're attempting to do. And so while that doesn't obviously matter in terms of the jury, because there is no jury yet, clearly it's intended for public consumption. And again, to your point, kind of showing the cards of this is going to be what we're going to hear more of in the evidentiary hearings and then eventually the trial itself.
Yeah, very much so. And frankly, I think that I think you're correct that a lot of what the defense is doing in this process is really geared towards the public perception of the case and the case for guilt, the possible arguments for innocence. What the defense is notably not doing is aligning itself with any kind of alternative theories of what happened. They aren't buying into like some of the narratives that we see online in the commentary and so forth. They really aren't asserting an alternative viewpoint at all at this point. And that's really not surprising because that's that's just it's a card that they're going to want to hold as close to the vest as they can for as long as possible. But we are seeing the way that they are trying to chip away at the cracks, and in so doing, I think trying to shift the narrative at least enough to encourage prospective jurors to keep an open mind. There may not be full answers to every question at this stage. And I think that is an important reminder that we do need to wait to hear what the defense has to say before we reach definitive conclusions. But that said, in terms of the goals of this particular hearing and establishing the legal justification to move forward to trial, I don't think that's going to be a difficult question at this point.
No, it seems as though the judge is, is playing it as fair as he can in terms of what he's allowing, what he's not allowing. He's clearly allowing pretty much everything into evidence. The question, of course, is, and I think of you every time he says that something can't be shown on the public live stream. I said, oh, Andrea's probably scowling about that.
Thank you. Yeah, no, I think that Judge Graff has shown an enormous amount of grace and generosity towards the defense in this case. We saw this, I think, most notably this afternoon with the questioning of the DNA analyst. This was really an accommodation from the state to kind of allow this analyst to be called by the defense in the first place, and then to kind of permit this very extended questioning that, under the specific rules that apply to Utah and the defense's right to present witnesses, really doesn't seem to fit squarely within that. So he does seem to be exercising an abundance of caution to make sure that he is as fair to the defense as possible, and he's giving them ample opportunity to make their position known.
Well, he is, but I would note that towards the end of the session today, he really started pointing out the clock. He started reminding them that, we're winding down, talking about, hey, you've now spent almost 3 hours going down the line here. What exactly do you want? I got the sense that he was pretty much done.
Oh, I think so too. But you notice it wasn't a hard yank on the leash. He did not lay down the law or stop the process or anything like that. He really kept inviting Mr. Burt to you speed things along, wrap it up. The closest he really got was putting some limits on some of the questions that Mr. Burt wanted to ask when Mr. Bride would object, and he'd say, all right, I'll let you ask this one and then we're going to move on. So really, I think trying to always find that middle ground between what he really wants to do and what is going to leave the defense with the fewest arguments that they didn't get a fair shake in this process.
Yeah, that's right. And I thought that Mr. McBride responding there did very well with his objections to speed things along, saying, look, this is, the relevance here is not germane to these proceedings. This is something for an evidentiary hearing. This isn't really what this preliminary hearing is all about. We're just trying to determine probable cause here. We don't have to have this whole argument about whether DNA science is real or not, which is clearly what Mr. Byrd was trying to do. But I also thought that earlier in the day, regarding that 1102 that Mr. Novak from the defense team had argued against, and again, Mr. McBride presenting his attempt to, and really did, by the way, I think, overcome the objection regarding a certain 1102 statement, getting into the motives or potential motives of the defendant here, talking about how Turning Point has a Christian mission, a political mission. And I thought that actually it was sort of interesting, because it seemed like the judge was going to rule in favor of the objection at first with Mr. Novak, but then it almost felt like Mr. Novak kind of just talked himself out of the win and just went way further than he needed to, getting into these really philosophical questions of politics and religion and where does it all mix. And I think at that point, that's where he lost the judge.
I think you might be right. I'm a Mr. Novak fan myself. I've reviewed a lot of his history, his practice, the work that he's done, and as a fellow defense attorney, I have great admiration for a lot of things that he's accomplished. But I do have to agree that I think Mr. Novak may have a tendency to be his own worst enemy sometimes when it comes to brevity. The problem is the more you talk, the greater opportunity you give, number one, the other side to think of their response to what you're saying, but also the judge's opportunity to kind of process it as well and come up with objections. I think the initial point that Mr. Novak was making, the state charged Tyler Robinson under one very specific aggravator that deals with political expression. There is a separate aggravator specifically for religious motivation. It wasn't charged for whatever reason. That was the decision. And I think had he made that point and kind of left it there, we might have gotten a different outcome. But the problem is that just through the digging into it and the continuing to speak, it gave the judge a lot of time to start thinking about, well, but isn't there a lot of overlap between these things? And I think ultimately that's what led him to rule the way he did, is that it's simply not as clear and fine a distinction as it might be when you're writing it down on a in a statute on paper.
And that was my thinking as well, and it really allowed the opportunity to bring in so many of those questions, gender issues and Christianity and politics and marriage and all of these things that probably wouldn't have been talked about otherwise. We're taking a quick break here. We're on with Andrea Burkhart from Andrea Burkhart Law. This is Human Events Primetime, special coverage, Real America's Voice.
Hour. I can say confidently, I think Josh Shapiro would be the vice presidential nominee if it wasn't for Jack Posobiec. And that is, I'm being honest.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio was 5% to 95%.
For one of the samples, yes.
You remember that?
Yes.
Does that mean the 5% was from Twiggs, and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculate the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
All right, Jack Posobiec back, Human Events, Primetime special coverage here on Real America's Voice. I want to say special thanks again to Allegiance Gold as well as Sav Media, our great friends over there, putting together all of the package that we have for supporting us and allowing us to have our security team and all of the production that we're able to do. So shout out to the SIGs as well, Parker, Rob, the entire team, for affording us this ability to be here. And we're on again with Andrea Burkhart from Andrea Burkhart Law. She is one of the best YouTubers out there, LawTube they call it, so make sure you go and check it out. But it is not for the faint of heart, because she is going to give it to you the way she sees it. She does not take sides, and that is why we like her so much. Andrea, before we go today, I guess one of the things that I wanted to ask is that, here we are, day 2. Tomorrow's a half day in court. I hear things in the courtroom, hear things in the courthouse, that the people had expected to be further along than we are already. We've really only had 3 witnesses thus far. Do you think there's a possibility that this goes beyond Friday?
It is possible. I would have said up until this afternoon that I would have considered them to be approximately on schedule, just given the number of witnesses that they anticipated and the time that's been allocated. But I do think that this afternoon likely came as a bit of a surprise to everybody in the courtroom about how long the defense was expecting to spend on this one particular issue and this one particular witness. I'm anticipating the court is already looking down the road to the defense is planning to call 2 other experts, and if they give them the similar treatment that they gave this expert today, then yes, we could be significantly behind schedule in terms of being able to wrap things up. So because of that, I kind of anticipate that we may see a tighter leash on that in the coming days, just to ensure that, if at all possible, they're able to get things done by Friday.
Yeah, I noticed that as well, because it's something where the clock management is really coming into play, and where clearly the prosecutors are wanting to present their evidence. They want to get it out there. They want to show it to the judge in terms of his magisterial role of providing, of getting that. And by the way, I really like the fact that this is done in a public setting as opposed to a grand jury, because a grand jury, that means all of this would be behind closed doors. And in fact, it is more beneficial to the defendant as well, because it allows for cross-examination, which doesn't exist in a grand jury situation. And of course, for those of us who want everything to be public and want this transparency, we are getting that. At the same time, though, again, to your point, that there really are these questions of the limitations of time and the fact that we only have 2.5 days left.
That is the trade-off. I mean, when you give the defense a voice, they're going to use it. And again, Judge Graff is, I think, doing everything reasonably within his power to make sure he's giving the defense every opportunity so that they can't come back at some future point and suggest that they weren't able to make their record or make their case on a particular issue. So it's not ideal. Time management is always a challenge in the court process, because you can't control what the other side is doing. The judge has a little bit more control over everybody, but even him, he can't. He runs the risk of violating important procedural rights if he cuts people off kind of arbitrarily or gives them a preset time, and they realistically need more. So I think he's trying to walk the tightrope here as best as he can, but efficiency is always a concern in our extremely busy courtrooms across the country.
No, it certainly is. And to that point, even given the high profile nature of this, it goes to show that there's still a lot of work that needs to be done. There's a lot of work that needs to go into it, and they are clearly doing so. What do you think that we should expect to look for in the next coming days?
Well, what seems to be the way that the state is presenting their case here is they're presenting it kind of chronologically, showing how the investigation unfolded. So they've already shown us the shooting, the scene, the kind of immediate response, the surveillance, and we've only just barely started to touch on the evidence that they obtained once Mr. Robinson did surrender, and then they were able to have the conversations with Mr. Twiggs. They were able to get the photographs of the evidence from the telephone and things along those lines. So I expect that's what we're building up to over the coming days. The question, just kind of from a logistical standpoint, is really where they intend to work in these other anticipated to be federal expert witnesses that the defense intends to call. They're always going to work around witnesses like that because they're flying in from the East Coast. They're going to want to accommodate that. So they'll kind of build the schedule around when those folks are available, and that's just a piece of information that we don't have.
That's exactly right. And when we look at it as well in terms of what's coming in and how long, I will say today that we did seem to have fewer objections. That McBride, he's my star of the day, just in terms of process and getting things going. That right at the very start saying, look, you guys made your blanket objection. It's a standing objection. We get it. You don't have to keep getting up and doing it over and over and over. And by the way, that's certainly something that if you do in front of a jury, I can't imagine is going to win you any points.
Yeah, I think that was a big improvement to the day. And I also think, frankly, it was helpful that it was Mr. Burt who fielded that objection for the defense and not Mrs. Nestor, who was the one who, did most of the objecting in the previous parts of the hearing. But it really does. I understand why the defense was doing that. There are so many procedural pitfalls when it comes to preserving your rights for future review. And they just want to be super careful that there is no argument that they have waived something because their objection wasn't specific enough or, it didn't clearly apply to this piece of evidence that is being addressed in court. So I do understand that, but at the same time, it is extremely aggravating for everybody to kind of have to endure it. So the judge's ability to kind of talk them off the ledge with that is something that we're, I think, all a little grateful for.
I couldn't agree more, especially being there and just wanting to get the story out, wanting to get the procedure going. Andrea Burkhart, we have to run. We're out of time. Where can people go to follow you?
Find me on AndreaBurkhart.substack.com. That's where I have the archive of the legal documents that I'm collecting in this case. You can also find me at @aburkhartlaw is my handle. You can find me under that handle on YouTube and Twitter. X.
All right. Thank you so much, ladies and gentlemen. As always, you have our permission to lay ashore.